Good morning, everyone, and all present in the session. I, Dr. Uzma, Assistant Professor, Faculty of Law, Integral University, welcome you all in today's session of the Faculty Development Program. The Faculty of Law, Integral University, Lucknow, in association of the Indian universities under the aegis of the Human Resource Development Center, is conducting 1 month faculty development program on the theme in integration of intellectual property rights principle into teaching, research, and professional activities. Today we have third session of module 3 of the FDP, and the topic of today's session is evaluation of IP laws, protection of research and academic creation. And to deal with this topic, we have our today's resource person, Dr. Sufia Ahmed ma'am. Welcome, ma'am.
Thank you.
Dr. Sufia Ahmed ma'am serves as an associate professor of law in the Department of Law at the School of Legal Studies, Baba Saheb Bhimrao Ambedkar University, Lucknow. She earned her PhD with a thesis title as Assisted Reproductive Technology, a critical legal study from BBAU. She has completed her LLM and LLB from BHU. Dr. Sufia Ahmed ma'am brings 14 years of teaching experience and possesses 16 years of research experience to her role. Her area of specialization encompasses jurisprudence, medical law, and ethics, surrogacy law, intellectual property rights, law relating to copyright, and Muslim personal law, reflecting her extensive engagement with both theoretical and practical dimensions of legal studies. She has received several prestigious awards in recognition of her academic contributions. Notably, she was awarded a certificate of appreciation by Baba Saheb Bhimrao Ambedkar University for publishing research in journal with high impact factor, Research Journal. Additionally, she has been honored with the Research and Academic Excellence Award in both 2022 and 2023 by BBAU, as well as the BBAU Gaurav Samman. These accolades reflect her commitment to research and her significant impact within her field. She has made significant contribution to the field through her published work with 2 books and several book chapters and research papers. Today, we are fortunate to have her, who has made significant contribution in the academic field. Therefore, without further ado, I would like to invite Dr. Sufia Ahmed ma'am to take the stage, where she will enlighten us uh, on the topic of evaluation of IP laws, protection of research and academic creations. The stage is yours, ma'am.
Thank you so much, Dr. Uzma, for giving such a wonderful introduction of me. I thankful to the organizer of this 1 month faculty development program for inviting me and for including me as a resource person in this FDP. And the topic which is assigned to me is evolution of IP laws, protection of research and academic creation. So as I gone through the topics which are given to other resource persons also, and I got that regarding IPR, IP laws, and evolution, meaning, and all this, there are so many lectures which was already uh, going on. So I will try to focus on protection of research and academic creation in my lecture, and I will try to confine my topic on those significant areas which are related to research for academician students, PG students, and those who are actively engaged in research activities. especially in university, higher education institution, colleges. And with regard to academic creation, there are so many IP laws related to academic creation, but I will confine myself to copyright law. So I'll start with some examples, some recent cases on copyright. So, is my PPT visible, Dr. Uzma?
Yes, ma'am. Yes, ma'am.
Okay. So, this is my topic, evolution of IP laws, protection of research and academic creation. And I will start some recent copyright infringement cases. This is the series, The Kandhar Ahijak on Netflix. And I think most of us have watched this series. And recently, Asia News International have filed a copyright infringement suit before Delhi High Court against the producer of Netflix series, The Kandhar Hijack. And it was because they said that there are some news clippings, some images of former Prime Minister Atal Bihari Vajpayee and Pakistani President Pervez Musharraf, and there are some other images of this Asian News International that has been used without the permission and acknowledgement. The news is that on September 13, it has been withdrawn by uh, Asian News International, which was case in Delhi High Court. Uh, the other case is related to Louis Vuitton, a very famous French luxury brand. Uh, they produce designer purse, belts, luxury purse, and all that. So they filed a suit for copyright infringement against the website hote24.com for offering their products for sale along photographs and images. And the case was won by Louis Vuitton, where the court ordered for 5 lakh cost also and stop the website for using Louis Vuitton's photos, images, and promotional materials, etc. This is the case related to ISKCON, and they have this Bhakti Vedanta Book Trust where they compile and publish the books which is related to the lectures of their guru, and that this case in April 2024 is against this website friendwithbooks.co, and they said that they infringed their copyright and they reproduce the material which is available in the books. Here the court ruled against this website and said that adaptation of those materials is also copyright infringement. Then another is this case related to the film Life is Good, which was released in 2022. This is related to the artist Nivedita Joshi, who's alleged that the song Palko Ke Palne, it was written by her, and there is no means credit given to the author of the song. So here court directed that the song and the author of the song should be given credit. And yes, this is big B. We all know that the another type of right which is recently emerged in India, that is celebrity right. Amitabh Bachchan, Jackie Shroff, Anil Kapoor. There are so many celebrities who are uh, going to court and protecting for their celebrity rights under copyright law against any unlawful infringement or against their right to privacy, their right to reproduction, distribution, character right, etc. And there are so many other cases, but I will not go into that detail. These are some few cases which are related to, especially related to copyright infringement. And because my topic is related to uh, academic creation and research, so I will try to focus on what is copyright and how we can protect our academic work with the help of copyright. So, copyright is one of the very recent IPR, and initially it was developed at international level uh, with so many treaties, conventions, like Bern Convention 1886, then Rome Convention 1961, then TRIPS, then WIPO Copyright Treaty 1996, WIPO Performance and Phonogram Treaty 1996, then Universal Copyright Convention. So the first one was Paris Convention. When we try to understand the evolution of copyright law at international level, because initially the copyright problem was not international; it was a national type of problem. Then when the problem arise because of jurisdictional issues and disputes, then some bilateral treaties has been emerged, and later on some multilateral treaties has been created for protection of copyright law at international level. And so many provision has been adopted in national laws also from those conventions. So in very short, I will discuss the evolution of copyright law. In 1883, Paris Convention was adopted, and the first time the principle of national treatment was adopted, which says that the same protection will be given to authors of the any original work which was given in their own country. The same protection will be given to other contracting parties also. Then the most important convention was Bern Convention for the protection of literary and artistic work, 1886. And Bern Convention was clearly and very directly related to the protection of works and rights of authors. And of course, authors, musicians, poets, artists, etc. So there are a few principles which was adopted in one convention. First was national treatment, that the same protection will be given to all the authors, the owners of the copyright, in other countries also. Then automatic protection, this is one of the very important provision, that copyright emerge automatically. There is no compulsory registration procedure of copyright in law. So this is the provision of automatic protection. And this third one was independence of protection, that protection is independent of existence of protection in the country of origin of the work. So these was the three principles, and some other rights which was given to the author of the work under Bern Convention was right to translate, right to adaptation, communication, broadcast, reproduction. So it was one of the very major international treaty. Moral rights were also recognized in Bern Convention. Then TRIPS, which was one of the very important international treaty regarding IP. So here, number of provision was there in TRIPS regarding copyright law, and now because of TRIPS, all the copyright dispute must be considered by WTO, and there are some other Bern plus provision which are given in TRIPS, and of course the provision of Bern now they are implemented under TRIPS. And after that, there is a WIPO copyright treaty, which is also a very special agreement under the Bern Convention, which deals with the protection of rights of author, especially in digital environment. So, how technology has affected the development of copyright. This is also very notable feature of WIPO copyright treaty, because earlier it was like a book. When Statute of Anne 1710, the first law of copyright has been passed in England. So it was the protection given to a book. And now from book to digital copyright. We have passed a very long journey, and now we cannot say that only literary, dramatic, musical, artistic, and cinematography, film and sound recording, only these are the subject matter, because there are so many subject matters which are available on internet also, and they can be protected under the copyright law because of certain protection criteria and because of some other reasons. So technology has affected the development of copyright law at international level and as well as a national level also. Then regarding performers right, producers of phonograms and broadcasting organization, we have Rome Convention, and that Rome Convention is specifically related to this performers rights and broadcasting organizations rights. So at international level, I'm not going into that detail, because I know that there are so many lectures which are related to international development, global development. I will confine to the research and academic creation, and when we do research in university, in college, or in academic institutions, so of course, there are so many things. It is not confined to book, research articles, research paper, book review, journal article, blogs only. In scientific community, they are doing inventions also, which are protected in patent law. So that is also one of the form of academic creation. But I'm not going into that, because I will confine my topic to copyright law. So what is copyright? Copyright is an exclusive right to do or authorize others to do certain acts in relation to original literary, dramatic, musical, and artistic work, cinematograph, film, sound recording, including computer program. So this is the definition of copyright under Section 14 of the Copyright Act. It means that the right which is given in copyright is creation of a statute. So it is an statutory right. And as I told you that it was Statute of Anne, which was passed on 10th April 1710, which was the first law of copyright. When if you talk about the history of copyright, then in ancient time there was no question of copyright, because in ancient time there was not any means to reproduce the work very easily, and the authors, the writers, the musician, the artist, they create the work for fame and recognition, not for any economic benefit. Economic benefit was there, but this was not the sole purpose. The sole purpose was fame and recognition, and copying was very laborious task, so and very expensive also. uh, some of the time the entire life has been spent only for copying the manuscript or any very important book or any manuscript or like that. But it was only after invention of printing press in 15th century that the importance and significance of copyright was recognized, and of course the rights of authors also was recognized. And after 1710, the authors, in the starting it was not for the lifetime and 60 years, it was for very short time, and again it was changed from Institute of Anne, then the copyright law, the common law copyright, then copyright law 1872, then 1911, then some other amendments, and then our copyright act, which is based on British copyright law. So what is the object of copyright? The object of copyright is to protect the author from unlawful copying and also encourage the author, composer, and artist to create original works. So the basic idea behind copyright is originality, and if the work is original, then only it will be protected in copyright law. So I will discuss about the concept of originality later. So the right is negative as well as positive. Negative in that sense when it prevent others from copying, positive in that sense when it give author some incentive, some right to assign, to get license. So copyright is that right which prevent others from unauthorized copying. And the basic principle behind the copyright is that there is no copyright in idea. So idea cannot be protected, and whatever idea which is going on in your mind, nobody can know that. So, and one thing which I want to mention here is that don't share your original idea with anyone unless and until you have some concrete result of that idea in the form of any article, any research paper, or any specific research. So if you will share your idea, and there are so many cases regarding this, that the idea has been shared, or in one case what happened that and this is very interesting case also, I will discuss this later actually, that someone has shared the idea, and then the other has worked on that idea. तो आपने अगर अपना आइडिया किसी के साथ शेयर किया, और वो आइडिया आपके माइंड में ही है अभी, और अगले ने उस आइडिया पे काम भी कर लिया, और फॉर एग्जांपल कोई ड्रामेटिक वर्क ही क्रिएट किया, कोई मूवी ही बना ली, और फिर बाद में यू रियलाइज कि अरे ये तो मेरा आइडिया था, तो यू कैन नॉट क्लेम दैट. द रीजन इज दैट आइडिया इज नॉट प्रोटेक्टेड. ओनली द expression of the idea, and that expression should be in a material form, whether it should be written or it should be any other form. So idea is not protected. And there are some common plots of movies, there are some common plots of, even in Indian serials, Indian TV serials, there are some common plots. And so many serials and movies are have been uh, making on the same plot. So nobody can say that I have copyright in a love triangle type movie, or I have copyright in some Saas Bahu type serial, because these are some common plots, some ideas. You cannot say that ideas are protected. Ideas can be so many, thousands of ideas can be there. So ideas are not protected unless and until you have record that idea, you have reproduced that idea, express that idea in any material form. And one important thing with copyright is that, because registration is not important, registration is only optional. So this is also one of the very major issue, because in trademark or in patent or in other copyright, there is a provision of registration, and after registration you will get the protection. Here in copyright, the moment when you create the work and the work will be published, so the copyright will be emerged without any registration. So that is why here, while publishing your work, or in the when is in the process of publication, so you have to be very careful, because it may be possible that the work has not been published yet, it is under review, it is under editing, and you are sharing your ideas with someone else, and then you said that it was my original idea, so you cannot prove that. Then yes, copyright is a bundle of rights. It has multiple rights. For example, a song, a movie song, one that has written the song, lyricist. Second, that composed the song, musician. Third, that given the soundtrack, sound recording. Then the director of the movie who picturized that song on actor and actresses. So there are number of copyright which is involved in a single work. So copyright is a bundle of right, and of course, the copyright can be assigned and licensed, and it has some economic as well as some moral rights also. So we have Copyright Act 1957, and under section 13 and 14, the subject matter and the meaning of the copyright is discussed. Section 13 says that copyright subsists in only original literary, dramatic, musical, and artistic work, cinematograph, film, and sound recording. So here the word original has been given. It means that uh, for a work to be protected under the copyright law, it must be original. Whether it is a literary work, dramatic work, musical work, or artistic work, it must be original. Because as an academician, we are confined to literary work. So I will not go into the detail of dramatic, musical, artistic work or cinematography and sound recording. I will discuss about literary work. What is literary work? So in copyright law, literary work generally it is the same meaning that we assume that the work of literature. And of course, it is the one of the very ancient protection from 1710. It is being protected under copyright law. And when we say that it is a literary work, so it means that something which is related to literature and something which is in a print, in writing, or something that is printed matter. But the question is that copyright law is not concerned with the quality of the work. It never says that it must possess some high literary value. It never said. So that is why the same protection will be given to the Godan written by Premchand and the novel of Raj Pocket Books, which is called Lugdi Sahitya or Lugdi Literature. So it never talks about the merit of that literature. If it is an original work, then it is literary work and it is covered under copyright law. The definition is given in section 2O, which says that literary work includes computer program, table and compilation, including database. So it is an inclusive definition, not very broad in the sense, but the US Copyright Act defines literary work for very broad term. And it says that works other than audio visual works expressed in words, numbers, or other verbal or numerical symbols regardless of the nature of material objects such as books, periodicals, manuscripts, phone records, films, tapes, discs, or cards in which they are embodied. So this is very broad definition of literary work under US copyright law. Under section 13, literary work has been included as the subject matter of copyright. And how can we say that this work is a literary work? So literary work definition, it never says about what is literary work or how can we decide. So for that we have to take the help of decided cases. And in a very old case of 1842, Holland Drake versus Trustwell, here, and the act was Literary Copyright Act 1842, where it was decided by the court that to qualify a book under Literary Copyright Act 1842, the creation must afford either information and instruction or pleasure in the form of literary enjoyment. So, information होना चाहिए, instruction होना चाहिए, या pleasure in the form of literary enjoyment. Again, it is a very subjective criteria. इंफॉर्मेशन इंस्ट्रक्शन तक तो ठीक है कि हमको कोई सूचना मिल रही है, कोई निर्देश मिल रहा है, लेकिन व्हेन वी टॉक अबाउट प्लेजर इन द फॉर्म ऑफ लिटरेरी एंजॉयमेंट, हाउ कैन वी से? बिकॉज प्लेजर इज अ वेरी सब्जेक्टिव टर्म. एक व्यक्ति को धूमिल की कविताएं सुन के बहुत आनंद आ सकता है, दूसरे व्यक्ति को धूमिल की कविताएं सुन के नींद आ सकती है, उसको प्लेजर इन द फॉर्म ऑफ लिटरेरी एंजॉयमेंट नहीं मिलेगा. तो साहित्यिक आनंद की जो अनुभूति है, इसका क्राइटेरिया बड़ा सब्जेक्टिव है और ये पर्सन टू पर्सन बड़ा वेरी भी करता है. तो हम ये नहीं कह सकते कि ये वो लिटरेचर है जो कॉपीराइट में प्रोटेक्टेड है अगर सबको इससे प्रसन्नता मिल रही है. नहीं, कोई नंबर ऑफ पीपल या स्पेसिफिक क्लास के लिए भी लिखा गया है, ग्रुप के लिए भी लिखा गया है, तो भी वो लिटरेरी वर्क में आएगा अगर वो इस क्राइटेरिया को फुलफिल कर रहा है कि इधर इट must be in information or instruction or present in the form of literary enjoyment. Now, this is the criteria. On the basis of that, we can decide whether any work is a literary work or not. इस तरह के बहुत सारे डिस्प्यूट्स हैं जहां हम देखते हैं कि इवन यूनिवर्सिटी और कॉलेजेस में भी देखते हैं जहां क्वेश्चन पेपर एग्जामिनेशन टाइम टेबल शेड्यूल देयर सो मेनी थिंग्स व्हिच वी आर मेकिंग इन द कोर्स ऑफ आवर एम्प्लॉयमेंट. तो जब उसके प्रोटेक्शन की बात आती है कि कॉपीराइट, हु ओन द कॉपीराइट, किसका कॉपीराइट है, तो फर्स्ट क्वेश्चन इज वेदर इट इज अ लिटरेरी वर्क और नॉट. हमें ये डिसाइड करना जरूरी है. फिर उसके बाद बाकी चीजें आती है, उस पर मैं अभी आऊंगी कि वेदर द क्वेश्चन पेपर इज अ लिटरेरी वर्क और नॉट. So, pleasure in the form of literary enjoyment, information, and instruction. Now, in another case, Apple Computer versus Computer Edge in 1894, the court says that for a work to provide information or instruction, हम कब कहेंगे कि ये इंफॉर्मेशन और इंस्ट्रक्शन प्रोवाइड कर रहा है, इट मस्ट बी कैपेबल ऑफ कन्वेइंग एन इंटेलिजेंट मीनिंग. So, a work to convey an intelligent meaning, it is not necessary that the work be introduced, understood by the general public. It is sufficient that the work is understood by a limited group with special knowledge. तो ब्रेल लिपि में भी अगर कुछ लिखा जा रहा है तो वो भी लिटरेरी वर्क है, because that is intended for the people with some specific or special knowledge. तो we cannot say कि मुझे समझ में नहीं आ रहा है तो लिटरेरी वर्क नहीं. That will be literary work. The language which I cannot understand, but that is a literary work if it is original and there are some other criteria if it is fulfilled. Then the question paper set by the examiner, whether it is a literary work or not, it was decided in 1916 in University of London Press versus University Tutorial Press Limited that the question paper set by examiner will be a original literary work. So if or because what is the reason? The reason is that the criteria of originality which was adopted by English courts at that time was skill, labor, and judgment. So the on the basis of that criteria, that whether the author of the question paper, whether the examiner of the question paper has invested a sufficient amount of skill, labor, and judgment while making the question paper or not. So if it is proved that the work is a result of the skill, labor, and judgment by the author, then that work will be an original literary work. So on the basis of that, the court has decided that the question paper set by examiner is a original literary work. Then there are so many things which are included in literary work, and there are so many things which are excluded. So, like for example, examination question paper, business letter, letter which I am writing to anyone, that is my IP. So, and if I post that letter to my friend, so I am transferring the right. The physical object is given to the friend, but the intangible right, the IP, the intellectual right of that letter is still with me. So I have not given that right to anyone. So the letter written by me, whether I am posting that letter to my friend, but the intellectual property is belong to me. Then स्कूल के टेक्स्ट बुक, इसको लेकर के भी देयर आर फ्यू केसेस. डायरेक्टरी को लेकर के there is one American case that I will discuss. What is not literary work? Single invented work is not literary work. Title of book is not literary work. Title of magazine is not literary work. Name, slogan, advertisement slogan, they are not copyrightable. They can be protected in other laws, in other IP laws, but they are not protected in copyright law. Now, who is the author? Who is the author of the copyright or who is the owner of the copyright? So, Section 2D says that who is the author. If it is a literary or dramatic work, then author of the work. If it is a musical work, then composer. If it is artistic work, then the artist. If it is a photograph, then photographer. If it is a cinematograph, film and sound recording, then producer, and now director also. The author is the person who creates the work. So author is someone who is responsible for creation of the work. Now, there are so many questions which are related to authorship and originality. Because when we talk about the concept of originality, it is the author of the work who is the first owner of the copyright, also, whose skill, labor, and judgment is the deciding criteria. That whether the author has invested a sufficient amount of skill, labor, and judgment to the resulting work or not. So, the concept of originality, of course, it is related to expression of idea, not the idea. So, the idea, whether it is original or not, it doesn't matter in copyright law. What matters is the expression of that idea, and that must be original. So when we say that expression need to be original, it means that it must not be copied from another work. So here it means it must be originated from the author. So originality means something that should be originated from your own mind, own intellect, your own imagination, then it is original. But there is a difference between originality and novelty. Copyright law never says that it should be novel, it should be new, some new idea only it will be protected. No, the idea can be derived from other work, but the expression of that idea must be original. So it means that there must be some input from the author, some creative input from the author, which differentiate the earlier work and your work. So if it cannot be differentiated, then it is not copyrightable, it is infringement. Now, regarding originality, there has been a debate about the concept, about the scope, about the different test of originality. And basically, there are two schools related to originality. And the first school is the creativity school, and second school is sweat of the brow school. The first school, it was a famous US case, Feast, which describe about this modicum of creativity, that originality requires that a work not be copied and contain a modicum of creativity. So here there must be some element of creativity. So this is creativity school. The second is the sweat of the brow, where according to this school, mere industrial collection involving the expense of labor or effort will be sufficient to meet the threshold for protection. Why I am discussing it? Because later we will try to analyze which test of originality is applicable in Indian copyright law, whether it is modicum of creativity or sweat of the brow. Modicum of creativity test has been given by US court in Feast publication versus rural telephone service. Here, the telephone directory, directly containing an alphabetical list of telephone subscribers, together with their towns and telephone numbers. Court says that it is not an original work because court says that facts alone or part of compilation are not original. Facts को copyrightable नहीं मान. Facts are not original, facts are not copyrightable. And factual compilation only eligible if it features an original selection or arrangement of facts. So here, court could not find that original selection. So that is why court said that telephone directory is not an original work. In British concept of originality, the test is labor, skill, or judgment. Here, the court in so many cases said that the author must have exercised the requisite labor, skill, or judgment in producing the work. But we cannot define what should be the amount, कितना होना चाहिए. ये तो case to case depend करता है. So, for the purpose of originality, the British concept has divided the work into two categories: new work and derivative work. New work is something that originated from the author. We have an idea which is very much original, and sit on the table, take a pen and a paper, and write down that idea. So, it is based on my imagination. For example, some poetries, stories, novels. So these are new works. These are not derivative works. They are new works because they are originated from the mind of the author. They are the result of the imagination of the author. So these works are original work under copyright law, and these works are protected under the law. Derivative work are those works which are derived from pre-existing works. इसका एग्जाम्पल हो सकता है ट्रांसलेशन, अब्रिजमेंट, न्यू एडिशन ऑफ एग्जिस्टिंग वर्क. सो हियर the concept of originality is playing a very important role because already a work is existed and you have created another work which is based on existed work. So a translation of a book, this is exclusive right of the author of the book to get the translation of the book. So you cannot claim that because you have translated the book, so you are the owner of the book which you have translated. Because that is the right which is given to the author of the original work. So just like a translation, there is abridgment also. There's a case related to abridgment, Macmillan versus Cooper. 1924 का प्रीवी काउंसिल का जजमेंट है जिसमें abridgment को लेकर के डिस्प्यूट था. और यहाँ regarding originality, the court says that in every case it must depend largely on the special facts of the case and must in each case to a very much a question of degree. So it is something which has to be decided on case to case. You cannot say that this is the concept of originality, the criteria, and this is applicable in every case. So it was the case related to abridgment, a book, Alexander's Life, which consists of 4,000 words, and that was abridged in a very shorter edition of 400 words, deleting some paragraphs, some materials. So the court said that abridgment is also a derivative work. And regarding originality, it is a question of degree. So you cannot say that the page number has been reduced, so it is a relative, it is a original work. And there is another case, another Indian case also, where the page number was reduced from 1,000 to 200, just because to get it readable by the school childrens. And here the court says that no, it is not an original work. So there are few cases related to this, and there are some cases related to originality in Indian law also. One case which is very interesting, I will discuss, is that Barbara Taylor Bradford versus Sahara India Entertainment Limited. It is a case of 2004, Calcutta High Court ka. In this case, the plaintiff Barbara Taylor Bradford, she was the author of a best-selling book, A Woman of Substance. There was a TV serial, Karishma, the Miracle of Destiny, and this serial was telecasted on Sahara TV. And the theme of the book and the serial was related to rise of a woman from poverty to extreme wealth. So here the theme were same. Now the story writer, the director, everyone has denied that they have not read the book written by Barbara Taylor Bradford. Now, the court said that no protection is afforded to ideas, plots, or themes under the copyright law. You cannot say that. And the court said a very interesting observation of Calcutta High Court. The court says that father-in-law, mother-in-law, son-in-law, daughter-in-law, love triangle, saas bahu, family drama. These are not protected under copyright law. These are the plots, the themes, the ideas, and you cannot say that these are protected. Anyone can make movies or serials or write a story or uh, produce something like that on some these type of plots. So court said that the Copyright Act protects expression and not idea. Therefore the author cannot have a copyright over the idea. As I said earlier, that idea is not protected. Idea can be common, there may be so many similarity between the ideas. In our academic life also we used to write on so many similar ideas. For example, in copyright also there are some mm, topics which are very similar, like digital copyright, cyber copyright on cyberspace, copyright on social media. So these are some topics which are very similar to each other. So nobody can say that because I have written on cyber copyright, so you cannot write. One, what is important is that the work must not be copied from earlier work. It must be originated from the author. So there must be some original contribution by the author. When I'm writing an article that is similar to another work, so I must be aware that my article must be original. There must be some original contribution from my side. There must be some additional contribution. And the definition is research is already says that it must be some original contribution in the existing stock of knowledge. So research is not only the compilation, research is not only the repetition, research is not only the reproduction. Research is the systematic or scientific inquiry in the existing stock of to add something original in the existing stock of knowledge. So you cannot say that you are doing research and you are not contributing even a single word or a single sentence or a para in the existing stock of knowledge. So this is something that we have to be very much aware about. That when we are involved in any research or academic creation, so the one and very utmost criteria or the aim of the research or objective of research is to contribute something original in the existing stock of knowledge. It should not be a mere compilation. So we all because we all are teachers, I think this is faculty development program, so we all are faculty and we are supervising dissertation, we are supervising thesis, we are helping the student to write articles. So we should always convey this to student that your article must be an original contribution to the existing stock of knowledge. And research is not only a compilation or only a reproduction of the earlier work. Whatever has been written, that has been written. You have to start your journey after that. You have to find out the research gap in the existing literature, then you have to write your article. So this is very important. Then regarding originality, we have two very leading cases, Indian cases. The one is Eastern Book Company case, and the second one is Delhi University copyright case. The Eastern Book Company case is also very interesting for law students and teachers because the case is related to Supreme Court cases, the SCC, the case reported. And in this case, what happened? This case was of 2007, decided by Supreme Court, and the name of the case is Eastern Book Company and others versus DB Modak and others. In this case, the Supreme Court cases, which is a law reporter, and it carries case reports uh, comprising the judgments and order of the Supreme Court, and they edit. They usually do addition. So they putting various inputs in the raw text, and and what they said that in constitute an original literary work, and it is original literary work under Section 13 of the Copyright Act. The respondent number one, they have launched a software called Grand Jurix and published on CD-ROM. And the respondent number two, they had brought out a software package called the Laws, published in CD-ROMs. What SCC said that the respondent software package has lifted verbatim from the appellant's work. They copied all the sequencing, selection, arrangement of the case, coupled with the entire text of the copy edited judgment, and they also copied the style, formatting, copy editing paragraph, numbers, footnote numbers, cross referencing, etc. And that is why it constitutes infringement of copyright. Now, the facts are very clear that Supreme Court cases, which is a case reporter, they copy edited the original Supreme Court judgment. The other two were the software package, which where they again produce the case reports of the Supreme Court, and the SCC has said that they have infringed their copyright. Supreme Court says first thing is that because the judgment of the Supreme Court, as well as we know that the judgments of the Supreme Court and High Court also, they are the work of government. They are government work. So government is the first owner of the copyright, the judgment of the Supreme Court. This is Supreme Court observed in this case. Now, the copy edited version of the text of the judgment, the court says that it has been created by the application of skill, labor, and judgment and capital, which is not trivial or negligible. So, here the copy edited judgment in Supreme Court cases is a derivative literary work according to Supreme Court. So, it is a clear case of infringement of copyright. Now, the question is that because the court, it is a very lengthy judgment also, and in this case, the court has cited all the international judgment from common law, English courts, American courts, Canadian court, Australian court, and quoted all the judgment, different schools like modicum of creativity and sort of the bro, and of course English cases related to skill, labor, and judgment. And then the court had applied the minimal degree of creativity. So if there is a question that which test is applied in India, so Eastern Book Company तक तो हम clear है कि minimal degree of creativity is the test which is applied by the Supreme Court, and the Supreme Court has concluded that the sweat of the brow approach was too generous to author, and the standard which the court has adopted is very near to English approach of originality, that is skill, labor, and judgment. So the Indian test of originality is based on skill, labor, and judgment, we can say, because of this Eastern Book Company case. But And after that, so many cases was interpreted by the high courts on the basis of Eastern Book Company. But in DU photocopy case, it was a very means a new type of copyright jurisprudence in India. We changed the meaning of right, we changed the meaning of fair use, we changed the meaning of originality. What happened in the case? That there was a photocopy shop in the premises of University of Delhi, that is Rameshwari Photocopy Services, and the Oxford University Press, Cambridge University Press, with Taylor and Francis Group, they have sued against the Rameshwari Photocopy and University of Delhi, and they said that they are photocopying, reproducing, and distributing the copies of their work without permission. It was something like that, that the books which are available in library, the student they get the book issued, and then they get the photocopy of those book at that shop. So here, the making of course material for student by photocopying, whether it is a copyright infringement or not. What the court said, that is very interesting. The court said that copyright is not a natural right; it is a creation of institute. So in jurisprudence, we uh, say that what is natural right, or what is statutory right, or what is a right which is legal right, moral right. So here the court says that it is not a natural right, it is a creation of institute. So copyright is a creation of institute. So all those conditions as limitation which are given in institute, that will be applicable on that right. First, second thing is that the owner of the copyright under section 14 does have the exclusive right to issue copies of his work to general public, but in this case copies are already issued because they are already in library and they are already sold. This is the first thing. Second thing is that the court observed that student can't be expected to purchase every book. So this is something that we can say the social and cultural aspect of IPR, that a student cannot afford the books published by those international publisher, Oxford, Taylor and Francis, and all that. So, and they cannot be the potential customers of the publishers. Then the court says that Rameshwari Photocopy Services doesn't serve as a competitor to the publisher because students are only taking advantage of the technology for their convenience. So the course materials, they are consist of the some chapters of the books, and some part of the book and compiled and photocopied. So here court says that the exception of fair use is applicable. Why? Because the purpose of this course pack is education, dissemination of knowledge. So here, the rights of the copyright holders are not validated. So this case is a clear-cut diversion of the earlier judgments where the Supreme Court has protected, we can say, the welfare of the students and the social and cultural aspect of the IPR, where this is very important that when we say that our student, when they can't afford those expensive books published by international publishers, and here quote says that and now in India 10% on one chapter, that rule is not applicable, which is applicable in other countries. So here the court is clear about that this is only because of the welfare of the student. So sometimes student ask the question how many pages we can get the photocopy, or how many chapters we can get the photocopy, or how many chapters we can get the photocopy. So if it is for the purpose of your study, for the purpose of your research, for the purpose of your private study under fair dealing provision, then it is okay to get the photocopy according to this judgment. So in copyright law, there are so many rights given to author. There are economic right, moral right, and the economic rights consist right to produce the work, then adaptation right, which is the conversion of one work to another. Like for example, conversion of literary work into dramatic work, or conversion of literary work into cinematograph film. Uh, for example, Three Idiots, that is the adaptation of the novel written by Chetan Bhagat. There are so many examples, and right of translation is also another right given to author. Then distribution right, performers right. For us this is very important, and because we usually give extempore lecture in the class, and sometimes we are not very much aware about the copyright protection. The thing is that uh, when we deliver lecture in classroom, so we act as performer, and under performance rights our lecture is protected. But the thing is that when we give extempore lecture, we should prepare some notes also. There must be some work, some homework, some rough work, so that will secure our right, that will give that additional security that we have prepared our lecture at home, we have prepared our lecture with the help of books and other materials, other sources. So and apart from performers right, when we prepare a lecture, when we prepare some even some ppt for class purposes, so in that case also we should be very much aware that while performing the lecture, or while showing the ppt, it should be there that we have prepared, and it cannot be recorded or it cannot be copied by the students. When you have given the permission to the student, yeah, then yes, you can record my lecture, then only they can, otherwise they cannot. It will be the violation of your right. So after performance right, uh, there is also one very important case related to authorship, and I will discuss this case also, because this case is some initial observation of court on this concept of originality, and the case is Walter versus Lane. It was the case of 1900 and decided by House of Lords. Sawa so saal purana case, and this case is very important uh, from the view of originality, the concept of skill, labor, and judgment, as well as the transformation of the idea of copyright also, because of the development of technology, because of the development of technological tools and others. What happened in this case, that there was a politician, Earl of Rosebery, and he has given so many speeches on some public platform. And there was two journalists. The one was Arthur Fraser Walter, and second was John Lane. Walter was recorded those speeches verbatim in shorthand, and then later transcribed them, adding some punctuation, correction, revision, and then published those speeches in the Times newspaper. Then other journalist, John Lane, he also published a book called Appreciations and Addresses delivered by Lord Rosebery. And that book, including those speeches which was taken by which was prepared by Walter and published in the Times. Here, the question was that whether the reporters of the speech could be considered as author under the terms of copyright. Now, the question is, before going into the judgment, what I am trying to say that the question is that who is the author? And in 1990, where there was, I think, there was no technology like today to record audio by audio visual means. So of course the author has the writer or the journalist has invested so many skill, labor and judgmental intellectual input while reproducing the speech. I always used to ask to my student, ki, if Walter versus Lane happened today, what will be the judgment of the court? And this indicate the transformation of copyright, the development of copyright. The court held that reporters, the two reporters, they are author under Copyright Act 1842 because that was the act which was prevailing at that time. The court said that the effort, skill, time they spent, it was sufficient to make them original. It was sufficient to make them original at that time in 1900. It was the case of 1900. So it was the majority judgment of 4-1, where House of Lords held that the reporters are the author of the work, means the speech which is published in the time and the book which is written. Now, this is the case which is the earlier response of the judiciary related to the doctrine of skill, labor, and judgment. And the case has been criticized later, and there are some other views related to the originality doctrine which is applicable in this case. But the importance of the case is that in 1900 they were regarded as author. In 2024, whether we can say the same. So it is the question. The answer of that can be helpful in deciding the present context, scope, and extent of the concept of originality. Because of the technology, because of internet, because of cyber, there are deep fake cases, there are cyber fraud, there are so many things which are happening regarding copyright infringement. Plagiarism is also there, that I will discuss if I will get the time. So we cannot say that Walter versus Lane would be same in 2024. So this is very important case related to the concept of originality. Then for the academician, for the researcher, for the student, there is one more concept that is important, that is joint authorship. Because we usually do collaborative research, we usually do research, write papers or books which are the product of collaboration. We usually discuss with our colleagues, friends who are like minded, and we make a group, and then we write papers, then we write some books and uh, review papers or all that. So section 2Z of Copyright Act says that work of joint authorship means a work produced by the collaboration of two or more authors in which the contribution of one author is not distinct from the contribution of the other author or authors. So, one thing is that there must be collaboration. Second thing is that the contribution of one author must not distinct from the contribution of other author. It means that if I and my friend, who is like-minded, and we have discussed that we will write an article on like originality under copyright law, and we discussed about it, and then we discussed that you write this and I write this, and then we will merge this article and then we will publish. This is not the work of joint authorship, because here you can distinct the contribution. Joint authorship means you cannot differentiate that this is the work written by one author and this is the work written by second author. So the work cannot be identified as the contribution is separate. It must be merged. And regarding joint authorship, there is a very important case of 1989 decided by Delhi High Court, that is Najma Heptullah versus Orient Longman Limited. And this the fact of the case is very interesting, that it is related to the book written by Maulana Azad, India Wins Freedom. Uh, the fact of the case was that when the book was written, uh, Professor Humayun Kabir, he was the friend of Maulana Azad, and he was writing the book at the instance of Maulana Azad. So Maulana Azad was given some material and some oral speeches and some other inputs, and Humayun Kabir has noted and compiled and uh, edited. So, but before publication of that book, Maulana Azad has died. Now, after 30 years, what happened? And this Orient Longman Limited, the publisher of the book, and the Professor Humayun Kabir. Now, the National Archive of India, the Professor Humayun Kabir has said that he wants to publish that book. So and because he had written those manuscripts, so he has a right, and there is an agreement between publisher Orient Longman, so they are entitled because Professor Humayun Kabir is the joint author of the book. Meanwhile, what happened that some heirs of Maulana Azad, they claim over the property dispute, and they said that the publisher cannot publish this book. And then ultimately what happened that because this case was related to joint authorship, and it was clear that Maulana Azad wanted to write that book by Professor Mayu Kabir. So the court says that what is important is intention. And intention was that the book should be written in joint authorship. So this is also important. That what if your intention is to write that book or to produce that work in joint authorship, then there is no question that who has written how much, on what is the amount of the contribution of one author or another author. Uh, then there is one more question, is the uh, work which is produced by employees, because we all are the employees, we are working in universities, colleges, higher education institutions. So when we produce something in the course of employment, who will be the owner of copyright? The copyright law says that author is the first owner. So if I am the author, if I have invested the sufficient amount of skill, labor, and judgment in producing the work, then copyright will be given to me. But as an employee, when I create a work, this is an exception to the rule of ownership, that if the work is created in the course of employment and on the instruction of the employer, then in absence of agreement to contrary, the authorship will be given to employer, because the work is created in the course of employment at the instruction of the employer. So if we are preparing a timetable And that is on the clear cut instruction of the head of department or dean of the school. So it is the work which is created in the course of employment. So here the copyright is wasted in the university. But if I am writing a research article, it doesn't matter whether I am writing that article in my cabin in university or at my home on my personal computer. That work is not created in the course of employment at the instruction of my employer. So here the author of that work is not the employer. When you are getting benefit from the employer, when you are using the resources, when you are doing that on the instruction of the employer, and when you are doing for them only, then it is in the course of employment. And there are cases where one doctor, he was using a computer and some other help, some technical help, some assistance from the company, and the company has given that task that you have to write this and that, and then he has prepared some lecture related to some disease, and then said that it is my original work. The court says that no, you have given this task by the company, that you will prepare this lecture with the help of the resources of the company. So here it is created in the course of employment. Now, what is infringement? Infringement is the unauthorized or unlicensed copying of a work which is the subject of copyright. So infringement is a clear violation of my copyright. Infringement is something which is very serious. Infringement is something which is very grave, and there are so many instances where we can say that this is infringement. Like if someone has adapted my literary work into another work without acknowledging my work or without taking prior permission of my work, that is infringement. Infringing copies produce karna, uh, performance, public performance where it is prohibited. There's so many different types of infringement, and infringement is a very serious offense, as well as it invokes civil action also. There are three types of remedies against infringement: civil, criminal, and administrative. And criminal proceeding may there may be imprisonment for 6 months, which can extend to 3 years, and minimum fine of 50,000, which can extend to 2 lakhs. So, infringement is an illegal activity, and there are so many cases related to infringement, copyright infringement in India. I will focus on only two, three, four cases. There is one case, uh, Yash Raj Film versus Sri Sai Ganesh Production. In this case, Yash Raj Film filed a copyright infringement suit against Sri Sai Ganesh Production on the ground that it copied their movie Band Baja Barat and produced Jabardast movie, which was substantial material similarities in terms of concept, theme, character, plot, story, script, and expression, among the other things. Here, what is important is that the court has extended the test of originality and said that films are protected as original work. And to distinguish between two films based on foundation, substance, uh, whether they have an impression that one work has the copy of other. So the court said that the Jabardast movie is the clear-cut violation of copyright. It is the copied work of YRF Productions movie Band Baja Barat. So the test is that whether the work is copy of another work. If there is an impression that the work is copy, while you saw the movie and you get the impression that this movie is based on that movie, so it is the impression that is created, that is emerged in your mind, and the work which is created is the violation of copyright. Then there are so many cases, but I will focus on only two, three cases. This Super Cassettes Industries Limited versus YouTube and Google. सुपर कैसेट इंडस्ट्रीज लिमिटेड ने यूट्यूब और गूगल के ऊपर केस किया और ये कहा कि दे आर मेकिंग सब्सटैंशियल प्रॉफिट फ्रॉम यूजिंग द कॉपीराइटेड वर्क अपलोडेड विदाउट अप्रूवल from the copyright owner and without paying a royalty for the same. The court said that YouTube and Google should stop distributing, reproducing, displaying, or transmitting on their portal any audio-visual work that is in the exclusive ownership of Super Cassettes Industries Limited. तो इसके बाद से ही जो पहले बहुत सारे गाने वाने सब यूट्यूब और गूगल पे चलते रहते थे, अब वो सब बंद हो गए. अब तो बहुत सारे ऐसे भी सॉन्ग्स हैं जो आप फेसबुक पर और यूट्यूब पे आपको नहीं मिलेगा, उस पे लिख करके आ जाएगा दिस इज कॉपीराइट प्रोटेक्टेड. So this is the reason. Now, for academician, for teachers, what is important is plagiarism. And there is a difference between plagiarism and infringement. Infringement is illegal. The provision is there in the Copyright Act. Plagiarism is unethical. And for plagiarism in India, there is UGC guideline which talks about what is plagiarism and what are the penalties in case of plagiarism. So plagiarism is an academic dishonesty, dishonesty. It may be intentional, it may be unintentional. When we say that it is a plagiarism, so it occurs when we use some words, some ideas, some works which are someone else. When we do not give proper attribution or acknowledgement to the author from where we get that idea. Plagiarism can be resulted in penalties according to UGC guideline, and plagiarism, fabrication, and falsification. These three are very important academic misconduct or scientific misconduct which we can observe in academic community. What is fabrication? Fabrication is creating data or result that are not based on actual observation or experiment. And this is very important to know. What we do, we while we supervising the dissertation or the thesis, we used to tell to a student to go to the society and collect the data while they are doing socio legal study, empirical research. So, and we rely on the data that they have collected. This is very important. Whether they have conducted actual research or not, whether that data is manipulated or whether that data is based on actual research which is conducted by the student or not. For that, as a supervisor, what we should do, we should ask for the original questionnaire filled by the respondent. That yes, come get the questionnaire, show me, I will analyze the questionnaire. That will save you. while you are using that work for publication, because fabrication is very important. It is very serious. And uh, and because of this fabrication, students, when they are fabricating, they are creating some false research result, the result which are not based on real research, or the result which are not based on the actual research conducted by the student. So this is very important. Then falsification is the manipulation of the data or changing of the data. For example, you have formulated some hypothesis, and after doing the research, what the student observed that the hypothesis has not been proved. So they manipulate their research, their data, and they manipulate their data to fit into that hypothesis. This is falsification. That is also academic misconduct. So we should also avoid this. We always teach a student to make alternate hypothesis. If your hypothesis has not been proven, don't worry. Make alternate hypothesis and then do your research. It is not always possible to prove your hypothesis, because hypothesis is only a hunch. It is a tentative assumption about the result of your research which has not been conducted yet. And when you are actually conducting your research, when you are going to society, when you are executing your research, you are collecting the data from the respondent, then it can be different. It is obvious. So there is no need to fabricate or falsify your data or manipulate your data for that, for to fit into that hypothesis. Then one thing is also important, that is uh, paraphrasing. Paraphrasing. We always tell our student to not copy the original idea as it is, but try to paraphrase so that it cannot come under plagiarism. See, paraphrasing without giving acknowledgement or without giving proper citation is also plagiarism. This is the question my student always they used to ask, that मैम हमने तो पैराफ्रेजिंग कर दी, हमने तो पूरा चेंज कर दिया, अब हमें इसमें रेफरेंस डालने की क्या जरूरत है? जरूरत है क्यों? क्योंकि वो आइडिया आपने कहीं और से लिया है. That idea is based on some other research work. So you have to give proper acknowledgement to the author of the original work. You have changed the words, you have changed the sentences, but you cannot change the idea. The idea is based on some other words. So proper referencing is important, proper referencing is necessary, whether you have paraphrased or not. Then another is self plagiarism. Self plagiarism is also plagiarism according to UGC. Self plagiarism means when you reuse your own work without giving credit. So when you are reusing your own work, you have to give credit to yourself. You cannot reuse your work without giving credit, then it will amount to self plagiarism. Sometimes we update our article, we update our book, we add some new cases, or after amendment we add some amended provision, or if there is some substantial change in law, or if there is some other development in uh, law or in opinion of the judiciary, then we update those work that is earlier published. In that case, we have to give credit that this work is based on this earlier work. So, and don't resubmit your entire paper to anyone. Always submit your paper to only one journal. When they refuse, then please send it to any other journal. Don't submit your article to so many journals. It is also unethical. So always try to submit your article to one journal first. If they refuse, then send to any other journal. I know that it will take some time. It will take so many time. Journal, they do not respond, even if it is a 6 month or 1 year or 1.5 year, 2 year. Care journal and Scopus listed journal, they do not respond usually um, after so many months. So patience is very important for teachers, for researchers. You have sent your article, now sit and wait. When they will respond, then they are not publishing your work, then only you can send your article to any other journal. So this UGC regulation of 2017, it says that plagiarism is an academic dishonesty, it is a breach of ethics, and self-plagiarism is also plagiarism. Then there are similarity check for exclusion from plagiarism. So there are some exclusion, and that is also very important to know. It says that all quoted work reproduce with all necessary permission or attribution. So the safe side is that you quote. If it is a judgment of Supreme Court or High Court, put a quotation mark. If it is something that you can quote, then quote it. Because the plagiarism regulation says that all quotation work are excluded. So quote it. This is the first rule. Then second, references, bibliography, table of content, preface, and acknowledgement. They are also excluded. So when you check your paper on plagiarism software, then always tick. Always exclude your reference, your bibliography, your table of content, your preface, and your acknowledgement. These points are there. These titles are there that what you can exclude. So you can exclude reference, you can exclude quotation, you can exclude bibliography. So exclude it. Then you will get the low report. Then another. The third one is that all generic terms, laws, standard symbols, and standard equations, they are also excluded. So generic term. Ab, I am the teacher in Baba Saheb Bhimrao Ambedkar University. Plagiarism checker says Baba Saheb Bhimrao Ambedkar University is plagiarized. So it is not my fault if it is plagiarized because it is a generic term. Or laws. When I am writing the Copyright Act 1957 and Authenticate says that Copyright Act 1957 is plagiarized. So okay, it is the fault of plagiarism checker, not mine. Because plagiarism regulation says that law is excluded. So for me, it is excluded. So if when I'm writing the Copyright Act 1957 or the Information Technology Act or whatever, or the Constitution of India, so this is excluded. So these things are very important to know. And then the regulation says, and that is very important, that the research work carried out by the student, faculty, researcher, and staff shall be based on original ideas, which shall include abstract, summary, hypothesis, observation, results, conclusions, and recommendations. So these are the content of your research work according to UGC. यूजीसी कह रही है कि जब भी आप कोई रिसर्च वर्क कर रहे हैं तो ये कंटेंट उसमें होना चाहिए. ये कंटेंट होना चाहिए एब्स्ट्रैक्ट, समरी, हाइपोथेसिस, ऑब्जर्वेशन, रिजल्ट, कंक्लूजन एंड रिकमेंडेशन, एंड दे शैल नॉट हैव एनी सिमिलैरिटी. ये ओरिजिनल होना चाहिए. दैट शुड बी ओरिजिनल. और उसके बाद कह रहे हैं इट शैल एक्सक्लूड अ कॉमन नॉलेज और कॉन्सिडेंटल टर्म्स अप टू 14 कॉन्जिक्यूटिव वर्ड्स. अब इसके बाद अगर स्टूडेंट कहते हैं कि हमने तो रेफरेंस डाल दिया, हमने तो साइटेशन डाल दिया, फिर क्यों प्लेगरिज्म आ रहा है, तो उसका कारण ये यहाँ पर 14 वर्ड्स की कैपिंग है, तो जब आप उसके ऊपर कर रहे हो तो वो प्लेगराइज है। पैराफ्रेजिंग करने के बाद भी यू हैव टू साइट, you have to give reference. Then there are 4 level of plagiarism according to UGC guideline. Level 0, level 1, level 2 and level 3. तो स्टूडेंट पूछते हैं कि कितना अलाउड है। इन प्रिंसिपल तो बिल्कुल भी अलाउड नहीं है, 0% है। लेकिन जब आपको जब आप when you're writing your thesis or when you're writing your research article, so regulation says that 0 to 10% similarity is minor similarity, so there is no penalty for this. So if your thesis is 9%, 8%, 9.5%, so you are safe because it says that it is minor similarity, so there is no penalty. Level 1, that is 10 to 40%. For student, if it is up to 40%, then in that case, you have to submit a revised manuscript within 6 months. Level 2, that is 40 to 60%. In that case, the student shall be debarred from submitting a revised script for a period of 1 year. And level 3, similarity above 60%, here registration of the student will be cancelled. So always try to be within 10. 10 के ऊपर जाने की जरूरत नहीं है, ये बात बहुत इंपॉर्टेंट है, बहुत ध्यान रखना है। There are so many other things, but due to paucity of time, I am not going to discuss those things in detail. But there are 2-3 more points which I want to discuss. That what are the acts which are not infringement? So here, Section 52 of Copyright Act says that a fair dealing of any work for the purpose of private or personal use, including research, criticism or review, whether of that work or of any other work, reporting of current events and current affairs, including the reporting of a lecture delivered in public. It means that fair dealing is protected. So, fair dealing is very important doctrine in copyright law, and it says that you can use the copyrighted work without the permission of the author, and it is not infringement if it is for the purpose of research and private use, criticism or review, and reporting of current event. So, and exception of fair dealing is not new. It is from Trips and Byrne that limitations and exception has to be given to the authors and others. And a very important case of US, that is Folsom versus Marsh, where 4 factors were laid down related to fair use. So, because I have given signal by the organizer, so always try to be fair in your research, always try to avoid plagiarism, always give sufficient acknowledgement to the author. और sufficient acknowledgement देने में क्या बुराई है, बल्कि मुझे तो ये ज्यादा अच्छा लग रहा है कि अगर हमने कहीं से कुछ लिया है, चाहे वो आइडिया हो, चाहे वो कोई सेंटेंस ही क्यों ना हो, कोई पैराग्राफ ही क्यों ना हो, अगर हम ऑथर को साइट करते हैं, अगर हम उसको नाम फुटनोट में लिख देते हैं, अगर हम उसको पूरी तरह रेफरेंसिंग में अगर हम उसको डाल देते हैं, तो उससे तो हमारी रिसर्च वर्क की वैल्यू बढ़ जाती है, हमारी रिसर्च वर्क की ऑथेंसिटी इंक्रीज हो जाती है। तो एज अ स्टूडेंट, एज अ रिसर्चर, इस बात को हमेशा हमें ध्यान में रखना चाहिए कि हम जहां से कुछ भी कॉपी करें तो हम सफिशिएंट एक्नॉलेजमेंट दें। Registration is optional, but if we want to get registered our work, we can get registered. Digital marking is also important these days, because when you are uh, writing an article and then you are sharing that article on ResearchGate or other sites, then digital marking is also important. Documentation process. If you are performing your work in public and you have some homework, some documentation process, then it will also very helpful for you. And of course, when you are publishing your work in the form of research article or in the form of book, always check publishing agreement. The agreement which they are sending, check those agreement word by word. Recently, I have sent one of my article to a scope at listed journal, and they sent that agreement, and there was one clause that how much help I have taken from artificial intelligence. So you can see the world is changing. Now AI is very important role in research. And if you have taken something from AI, then you have to declare that also before publishing your work. So we can we can we can take the idea, we can take the information, but don't reproduce that AI generated material. Always try to read good books, good journals, good articles, and then create your own idea. So these are some measures to protect your research. And if you have any question, any query, you can ask. There are so many things, but I will stop my lecture here because of the paucity of time. And if anyone have any question, any query, they can ask. I will be very happy to reply. Dr. Uzma, is there any question?
Yes, ma'am. What There is a question from Abhinya Taragi. What strategies should policymakers consider to address the disparities in IP law enforcement between development and developing nations as technology continues to evolve?
Yes, this is very important question, and this is very burning issue these days also, because because of these technological advancement, cyber, internet, social media. Even sometimes we don't know what we have to do because of these things. And of course, policymakers should take into consideration. There are some copyright infringement cases which are happening on internet, on social media, on cyber, on deep net also. So digital copyright is very important. But we don't, we cannot say, because the question of digital copyright or cyber copyright are very much international, global. They are not limited to one jurisdiction. They are not limited to one law for one country, because one who is operating that is from another country, one who is affecting that is from another country, one whose law is violating that is from another country, one whose rights are violating that is from another country. So yes, this is very important that we should take into consideration this technological development, and we should make our IP laws more strong and updated with view of this technological development. Thank you, Abhinya, for this question. Dr. Uzma, how can institutions ensure that their IP policies promote equity and inclusivity, especially for underrepresented groups in academia? IP policies of universities are regulated by UGC. So UGC has created some mechanism for that. And I wanted to give it in detail how this mechanism works. There are some institutional academic integrity panel, then departmental academic integrity panel. So from top to bottom, there are mechanisms for this promoting the IP policies and for checking the plagiarism. IP cell is there, IPR cell is there, then Institutional Innovation Council. They are now every university, higher education institution, they have established this IIC in their institution. So I am also the member of my IIC and some other IIC of other institution and colleges. So we always try to include the students, the researchers in our programs, in our process, in all that. And for IP promotion, uh, only we, an academician or teacher, we are responsible for it. When we do good research, who is going to stop us? This is only depend upon us. No one is stopping, no one is preventing you to doing good research. And UGC is always promoting research and original work and all those. There are incentives, there are so many things in universities, in colleges. You get incentive for your paper, you get financial aid for presenting your paper in other institution, in other countries also. In some universities, student and teachers, they get some incentive for publication also, for publication of books or articles also. So it is up to us. It is not, we cannot say always that it is university or institution or all that. When we are doing good research, then okay. Dr. Uzma, any other question?
No, there is no other question. Thank you so much. Now it's time to formal vote of thanks. I would like to extend my sincere thanks to Dr. Sufia Ahmed ma'am for the insightful session on evaluation of IP laws, protection of research and academic creations. Her expertise has greatly depended our understanding of the importance of intellectual property in academia. No one better than ma'am could have guided us on this topic with the deep understanding and vast knowledge on the topic. So we are extremely grateful to you, ma'am, for taking the time out to join us and share your valuable wisdom and insights on the topic. Your presence has truly um, elevated this session today, and also thank you to all the attendees and for your active participation. We look forward to applying these insights in our work. Now we are ending today's session here. Thank you, everyone. Thank you, ma'am.
Thank you, Uzma. Thank you so much.